She falsified the governance records, she fabricated a control clause. She is trying to steal my firm. My father's voice cracked across the federal courtroom with the kind of theatrical outrage that used to win juries. It was the same voice he had used for 30 years, measured when it needed to be measured, thunderous when it needed to intimidate, always confident that volume could substitute for certainty. He stood at the plaintiff's table like he owned the air itself, one hand braced against polished oak, the other pointing directly at me. She couldn't build anything of her own, he continued, jaw tight, eyes blazing. So she manufactured a corporate coup, that compliance trigger she's claiming, I never authorized it. It's a forgery. I didn't look at him, I looked at my watch. 10:06 a.m. right on schedule. Judge Marion Keaton leaned back slightly in her chair, studying him over the rim of her glasses. Her expression didn't shift, but something about her stillness suggested she was no longer simply listening. She was evaluating. Mr. Whitmore, she said calmly, you are alleging that your daughter inserted a fraudulent clause into your firm's operating agreement. Yes. Your Honor, and you are making that allegation under oath. His chin lifted slightly. Yes, a silence settled over the courtroom, but it wasn't passive. It felt dense, compressed, like the pressure before a structural beam gives way. Before I tell you what made my father's partner stop turning pages and simply freeze, tell me where you're listening from and what time it is for you right now. I always wonder how far stories like this travel. The silence stretched. I sat perfectly still, hands folded in my lap, navy blazer crisp, posture unremarkable. I didn't flinch when he called me resentful. I didn't blink when he described me as obsessive. I didn't react when he said I'd spent years plotting revenge. He needed an enemy. I was giving him a mirror. Your Honor, he continued, pacing now, abandoning the podium like movement would fortify his position. This so-called reputation and governance trigger clause does not exist in any legitimate version of our documents. She works in compliance consultancy, risk modeling, paperwork. She does not understand litigation practice. She manipulated our digital records. Douglas Hale, his longtime partner, leaned toward him and whispered urgently. My father brushed him off without looking. She's been jealous for years, he pressed on. Ever since I asked her to leave the firm, this is retaliation dressed up as governance. Judge Keaton nodded once toward the clerk. Display Exhibit 12. The overhead monitor flickered on. A PDF of Whitmore and Hale's amended operating agreement filled the screen. Page 63 was highlighted, Reputation and Governance Trigger Clause. My father laughed, that's not our version. The clerk enlarged the metadata panel. Original creation date, March 3rd, 2 years prior, draft author, Douglas Hale, revision approval, Thomas Whitmore. Digital signature verification, confirmed. The air in the room shifted, Douglas's face drained of color. Tom, he murmured, barely audible. My father shook his head. It's been altered. Judge Keaton tilted her head slightly. Mr. Whitmore, this document has undergone independent forensic analysis. It originated from your internal server. He opened his mouth to argue again. 10:09 a.m. right on schedule. 2 years earlier, Whitmore and Hale had been unraveling quietly, not publicly. Not dramatically, just a slow internal bleed, 3 consecutive litigation losses, a malpractice claim narrowly avoided, escalating insurance premiums. A credit line renewed at terms that smelled like desperation. He never called it collapse, he called it temporary compression. Compression suggests rebound, this was decay. The night he called me, his voice was careful. Alina, he said, not dad, never dad in business matters. I need strategic input, not help input. I was sitting at my dining table, surrounded by spreadsheets mapping reputational exposure indices for a biotech client. I had already run his firm's public financial data through my own model out of habit weeks earlier. The red flags weren't subtle. Liquidity? I asked. He paused. It's transitional. Payroll, another pause, managed. That meant no. 3 days later, we met at his office. I remember the leather chairs, the smell of polished wood. The framed newspaper clippings about his most famous wins. He looked tired but defiant. I need capital without surrendering control, he said. I nodded. I know someone, I told him. Aurelia Strategic Holdings didn't exist yet. It would the next morning. I structured it under my middle name to avoid immediate association, governance-focused private capital, minority stake. Operational non-interference, reputation-linked protection. He skimmed the proposal like he skimmed everything that didn't involve his own reflection. How much? He asked. $1.2 million staged, I said, and control remains yours unless triggered. He smiled at that. Unless triggered, he didn't ask what constituted a trigger. Back in the courtroom, his voice grew louder. She manipulated our board portal, inserted language retroactively. Douglas stopped whispering and began flipping pages rapidly, then slower. Then carefully, Tom, he said again louder now, it's here. Judge Keaton folded her hands. Mr. Whitmore, the clause states that if a managing partner publicly alleges criminal misconduct against a principal governance stakeholder without substantiated evidence, temporary control transfers pending review, he scoffed. Boilerplate, no one enforces that. It is enforceable, she replied when signed. He finally looked directly at me. You wouldn't, I met his gaze evenly. I didn't, I said softly. You did. The reputation and governance trigger clause wasn't ornamental. It was engineered, tied directly to underwriting covenants. Reputation isn't abstract in corporate law, it's insurable. It's quantifiable and it's contractually protected. Even if that clause exists, he said quickly, voice sharpening, she's acting in bad faith. Bad faith would imply fraudulent insertion, Judge Keaton responded. We have established authenticity, 10:12 a.m. right on schedule. In the back row, a man in a gray suit shifted slightly, Harbor National Risks underwriting representative. He had been notified automatically the moment court filings went public with allegations of internal fraud. My father didn't notice him. He never noticed the quiet ones. Your Honor, the underwriter said calmly, standing, given the sworn allegations of governance fraud and the activation language in Section 8.3 of Whitmore and Hale's coverage agreement, Harbor National is initiating provisional suspension pending review. My father turned toward him, disbelief morphing into alarm. You can't, we can, the underwriter said simply. Without malpractice insurance, a litigation firm cannot operate. Douglas sat down heavily. Judge Keaton glanced at the clerk. Given the insurance suspension and the contractual trigger, temporary governance control transfers to Aurelia Strategic Holdings pending compliance review. The gavel struck once. It wasn't loud. It didn't need to be. My father stood frozen. She can't run my firm. I don't need to, I said. I only need to stabilize it. His laugh this time was hollow. You engineered this? Yes, I said calmly. I engineered protection. 2 years earlier at Thanksgiving, he had raised a glass and gestured toward me. Elena works in compliance modeling, he'd told his colleagues, corporate housekeeping. They'd laughed politely. I had smiled. Housekeeping means knowing where everything is. And where everything can fall. Outside the courthouse, the afternoon light was flat and indifferent. News vans were already lining the curb. He caught up to me on the steps. Elena, not Elena the consultant, just Elena. Why? I turned slightly but didn't face him fully. You accused me of forgery under oath, I said evenly. You designed it so I would, he replied. I shook my head. I designed it so if you ever confused ego with judgment in public, investors wouldn't pay for it. He stared at me, searching for something, anger, cruelty, satisfaction. There was none. You could have warned me, he said. I did, I replied. 2 years ago you called it paperwork. For a moment something flickered in his expression, recognition. Then pride swallowed it. 6 months later, Whitmore and Hale still existed. Smaller, controlled by interim governance, under review. He retained equity. He no longer retained authority. I didn't dismantle his firm, I recalibrated it. Power doesn't shout, it drafts clauses. If you've ever been underestimated because you weren't the loudest voice in the room, remember this. Silence isn't weakness. It's leverage. Tell me where you're watching from. And if you believe strategy always outlasts ego, stay with me. There's more to this than a courtroom.